Welcome to Deal Us In, a podcast brought to you by McGuireWoods. Deal Us In promotes the advancement of women in private equity and finance through conversations with women in the private equity and finance space. These conversations provide both insights and practical takeaways to inform your deal work and enhance the culture of your organization. If you're ready to drive the industry toward a more inclusive and diverse environment, then it's time to come to the table.
Welcome, everyone, to Deal Us In, a Women in Private Equity and Finance podcast brought to you by McGuireWoods. Today, we're welcoming back Jodie, Lawson, and Susan Rodriguez, partners at McGuireWoods. This is our third annual episode together. In 2021, we did an episode called Skeletons in the Closet. In 2020, we talked about horror stories and keeping monsters out of your deals. And today, we went with a less grim but equally festive theme, deal resolutions for the new year. Jodie and Susan, would you please remind our listeners a little bit about yourselves?
Yeah, thanks so much for having us, Kelsey. I'm Jodie Lawson. I am a litigation partner in the Charlotte office of McGuireWoods, and I focus on business litigation, energy litigation, and financial services litigation.
And hi, it's Susan Rodriguez. I'm also a partner in our Charlotte, North Carolina office. I work mostly on investigations and regulatory issues that come up in deals and then helping companies respond to investigations by the government. And so we'll talk a little bit about how that comes up in deals today.
And Susan, I think you're going to kick us off talking about some deal resolutions related to I-9s with an outlook towards the new year. What have you seen in the past year?
Well, Kelsey, you and I have worked on a lot of deals together this year, and we've seen a mix of different things. I've talked about this on some of the podcasts, but I always think it's good to sort of set the table. I talk to a lot of private equity people, and they always ask Susan, tell me about I-9s. This seems to be an issue that's more and more front and center in deals, whereas a few years ago, nobody even really asked questions and diligence about I-9s. And so why is it becoming such a big issue? And I think the answer is there's a few people, RWI deals, nearly everyone asks on an RWI call now about I-9s. Have you looked at I-9s in diligence? What do they look like? Oftentimes, if there's issues, those Form I-9s, coverage will be excluded. And so I think there's a real trend of seeing that more and more. And so it's forced people to look at I-9s more diligently. So for those who are not so familiar with I-9s, let me just back up. And, some of you all may have a lot of familiarity. Some of you may have just a little familiarity. So I'll just remind everybody what the requirements are. So every company, doesn't matter how big or how small you are, if you have employees that were hired after 1986, which is pretty much everyone these days, you have to have a Form I-9 on that employee, and you must keep it for the whole tenure of that employee. And there's even some retention rules. You have to keep that I-9 even a little bit after that person is terminated. And if you fail to do this, it's this 2-page government form, you can be fined. And there's both civil and criminal penalties. And so, again, that's why it's come up, really important, especially for our private equity folks. Nobody wants to find themselves in a criminal situation, right? And those are, just to not scare everybody here, those are really meant for very egregious situations. And so, by and large, we're talking about civil penalties here. But that's why it becomes so important. And so when we're doing diligence, Kelsey, one of the things that we've worked on together is just coming up with those standard diligence questions. Do you keep I-9s? Are you in a state that also requires you to participate in E-Verify?
Yeah, exactly. And certainly it's come up in, I think, every RWI deal I've had in the last couple years. It's been a set of questions on the call, and I think people are likely to be surprised by that, especially because they consider immigration issues to be kind of involved in select industries, but RWI doesn't see it this way, and the regulations apply across the board.
That's right. That's right. And some deals are maybe you kind of have to look at the deal. We see in food service, manufacturing, agriculture, in those deals, it's sort of front and center because if you learn that you have unauthorized workers, you could lose workforce. And if you don't have employees, of course, that's going to affect the purchase price. And so these are often issues you need to know up front. And, Kelsey, I think something we have both seen this year are people are not doing this on the back end of the deal. In other words, it's not just part of the standard diligence questions, but we have a lot of people now putting I-9 issues at the front of the deal because they want to know if there are any issues before they get too far down the road.
Yeah, I think that's especially true in the industries you mentioned or particular geographic areas where it's more likely to come up. But certainly, if you're not going to have a workforce there, that has to be one of the issues that you're considering from the jump on your deal, especially if people are a large part of your business.
Right. And the general corporate rule that I think it's really important for anybody in private equity who's doing deals to know this rule, but you sort of had two options on the table when you're looking at I-9s. So either you can keep the I-9s and you inherit any liabilities. So if they're bad or if they're untimely or you have problems with those I-9s, you might inherit those liabilities if you keep those I-9s. The other alternative is doing all new I-9s, and you can cut off those old liabilities. But the only issue with that is it's a very administratively burdensome. So, let's say you have 500 employees. There's a really strict time frame to get those I-9s done after a deal closes. And, if you have 500 employees, you may not have the bandwidth to get it done on time. And if you don't get them done on time, then you can be fined for that too. So you might even create more issues. There's a real calculus that goes into, should you keep the I-9s or should you do all new I-9s? And Kelsey, the question that we get a lot too is, okay, well, what about an asset purchase? I'm only purchasing those assets, but that rule still applies because you still may be keeping the employees. And so I think there's always a lot of confusion. I get a lot of questions about that. Unfortunately, this is kind of one of those carve out immigration rules that if you keep those employees and keep the I-9s, you still inherit the liabilities, even if it's an asset purchase deal, which sort of flies in the face of some of the corporate rules that we're normally accustomed to.
Yeah, that's definitely something that we hate to hear on the corporate side is that some liability could follow you through an asset sale because that's supposed to be our safe space, But
Exactly right.
but I think that the timeline being so rigid and these other, the liability following you along, really ups the ante for like making this a particularly serious issue to consider. I know that we've seen it come up in a lot of our deals in different contexts at different stages in the game, usually at the forefront, but it can be, unfortunately, just something that it could be a deal killer, could be something that you just need to work around. But I think a lot of people, in addition to the asset sale issue, might think, well, can I just approach these selectively? If we have a workforce of like 500 people and there's only issues with a few people, can I just redo those selective I-9s? And Susan, what's the role around that?
Yes, great question. We do get that question a lot, but unfortunately, it's a all or nothing scenario. So the rules are there's both Department of Homeland Security and there's also Department of Justice, Immigrant Employee Rights Section rules. And what they tell us, the government rules tell us, is you have to either complete all new I-9s or you have to keep what you have. You could fix some of them in an audit context, but you can't do a new I-9 selectively for employees. That would be against the rules.
Right. And I think we run into that too with the sellers on their side of things. when they realize that there might be issues with their I-9s, going back and asking for new from selective people, which is its own ball of wax, right?
Yeah, sometimes we've had people, we're on the buy side, for example, and we have sellers who start doing a lot of things with their I-9s. They might actually create more issues. So that's always something that we're looking out for too. Have they suddenly created more issues than there were even before in an attempt to fix it because maybe they didn't fix it correctly, consistent with the rules? So we've certainly seen that. Kelsey, something that you said too was, a deal killer. We have, and I think that's the sort of issue here, is we have seen I-9 issues kill a deal, and that can be very scary. But we've also, I think, developed a pretty good way to navigate these issues too. So when we see that there are I-9 issues or compliance issues, we could kind of take a broad look at what's really going on. Are these just technical paperwork issues? Those we can fix. We can navigate that pretty easily. If we are seeing more issues in potentially unauthorized workers, or just, they don't have I-9s or they haven't complied at all, that's where it gets a little more serious. Or perhaps, Kelsey, we've had issues like this before where we find out there's been past audits and six-figure penalties from the government for noncompliance. And how do you deal with that? So where we've had those types of issues where, we know that there was a government audit and they've been fined in the past, that's where alarm bells should be going off for everybody. Because if the government has already fined them for something, that means that there were issues. And so likely the government's going to come back at some point, maybe when you purchase the company, and they're going to be looking to see if you're in compliance. So that's one of those times you really want to make sure that you're paying attention to those issues. And I think one of the things we've done really successfully is indemnification provisions. We've done special indemnity, especially if it's RWI deal and that's going to be excluded from coverage. You definitely want that special indemnity. And I think you have to be sort of bold about asking for that. You don't want it to sour things, but at the same time, you got to protect yourself. So we've seen those special indemnity, and there's a lot of different ways to do those special indemnities. We have seen where we just put a special indemnity together. We don't ask for any money up front. We just say if there are issues in the future prior to close, we get fined for something, there's a government inquiry, you're going to indemnify us for that. And everybody sort of takes everybody at their word. But there's sometimes there's more serious situations like the one I talked about where there might be a six-figure penalty on the table with the government, and you really got to protect your client in that instance. And those are times where I usually look for some sort of holdback or put money in an escrow account, because you need to hold back some money to cover those issues because it's a very high risk issue. And I told Kelsey I would say this. I think we probably have this disclaimer at the beginning of the podcast, but obviously every situation is different. And so, you'd always want to get good legal counsel on your specific situation. Nothing in this podcast should be construed as legal advice to your specific situation, but just to give everyone an idea of what we see out there for those more serious situations. We do oftentimes do holdbacks or escrow accounts.
Well, and the reason for that, I think, is super important to focus on, which is you don't want to have an indemnification provision that isn't even worth the paper that it's written on. So
exactly,
you end up in a situation where, great, you feel like you've taken all this comfort, you've got an agreement to indemnify, you've got an indemnification provision in your agreement, and then something bad happens and you go to collect on it and there's nothing there. And so that is why you need to take a holistic approach to figure out in advance, what is your exposure? What are you looking at here? If it's something small, maybe you could get comfortable with just a indemnification provision in the agreement. But if it is something that could potentially be more costly, that could really change the economics of the deal after the fact, then that may be a situation where you do want to ask for a specific holdback, agree on an amount certain, and set that aside so that that you have that protection there, that comfort there, that will give you what you need in order to actually get the deal done.
Yeah, and I think the approach on that is can be driven by the issues that you're seeing. I mean, everything's going to be tailored to, like, if it's just paperwork issues, we don't think that there's unauthorized workers involved. It seems like they just didn't complete the paperwork right. Oftentimes, even in an RWI situation, that might just be a conditional exclusion while we get things cleaned up the days following closing and get the paperwork in place properly in accordance with regulations. But if it's something more drastic, like an audit, or like there may be unauthorized workers, or it's not clear what's going on, those are the things where we might be looking at a holdback or an escrow. And of course, we're looking at special indemnities are typically going to relate to the past practices because the new practices are on buyer's watch. So you still need to, if you're on the buy side, be working to clean up whatever you can within the timeline set by regulations. But this could protect you for purposes of if someone comes along, the government comes along and is looking back at the seller's past practices and wants to hold you accountable. But the kind of the two-pronged approach is really fixing whatever the issues were in accordance with regulation. And if there's something from the past, having an adequate indemnity and a resource for that indemnity on the front end. And Jodie, I'm glad you jumped in because we're switching gears into indemnity. I mean, what have you seen in the last year or so that you think is worth mentioning as we go into this new year?
Well, there are a couple of things that I wanted to highlight. And I think the key one is, you want to make sure the indemnification is worth the paper that it's written on. So you want to make sure you can collect on it. But there's also some nuances to actually drafting and negotiating the indemnification provision that courts have interpreted that people need to be mindful of to make sure that when you include an indemnification provision in your agreement, you want to make sure that it's actually going to be enforceable in the event you need to exercise it later down the road. So some courts have looked at indemnification provisions that are too broad. And if they're drafted too broadly, it's possible that a court may find them unenforceable. Now, in most agreements, what we typically see is a provision. Usually this is one of the throw-ins, but an important throw-in at the end, which is if a court were to find one or more of the provisions in the agreement to be unenforceable, that the other provisions in the agreement would still be in full force and effect. But this is one where you want to be careful that you've appropriately negotiated your indemnification provision so that it's not overly broad and thereby rendered unenforceable by a court. One example of this, and courts are split on this, and so you'll need to look at the particular state law that governs the agreement that you're negotiating, but an indemnity clause that purports to relieve a party of liability based on their own negligence, some states have found that those provisions are void because they're against public policy. So it's great to negotiate a broad provision, but you need to know that courts are going to scrutinize those. And if they are found to be too broad, they may not actually be enforceable and thereby will not be offering you the protection that you thought you once had. One other thing that we've seen is courts are going to look at a foreseeability standard when you're looking at an indemnification provision. And so that's what you'd look at when you're looking at a traditional breach of contract scenario. And so you also want to make sure that the provision is broad enough and so that it includes things that are foreseeable. And then you may need to have some special or additional language included in there if there is something that you want to have indemnification on that may not be foreseeable based on the facts and circumstances of your deal. So think carefully about that. And I think that falls right into line with some of these I-9 issues that we've been discussing. You want to make sure that, maybe it's foreseeable that there could be paperwork issues. Maybe it's foreseeable if the government has already levied a fine against the company that you're buying. And so you want to think about those things, but if those have not happened, then you want to make sure that your indemnification provision would be found by a court or interpreted by a court to be reasonably foreseeable in what you're seeking to recover. One last point, just for everyone to think about, and hopefully, nobody ever gets to a scenario where they've worked on a deal and somebody ends up going bankrupt, but it is important to remember that a duty to indemnify may not survive bankruptcy. Again, that's going to depend on facts and circumstances and the state in which you're in, but remember that. And that may be another scenario where if you are concerned about the liquidity of the company that is offering the indemnification, then that may be a good situation where you actually ask them to do a monetary set aside so that you aren't trying to collect from somebody who's in a bankruptcy process.
That makes a lot of sense. And Jodie, maybe we can talk a little bit about this. And there's always a difference between an escrow and a holdback. So a holdback typically the money is set aside in your own accounts or in a separate account that the buyer controls and serves as a resource for indemnity. So it's in your hands. Escrow means it's in a third party's hands and subject to an escrow agreement. So those are kind of your two alternatives. You can also have set-offs against if the company's doing well and there's earn-outs or things like that. You can have set-offs against those set-off rights against other monies, like if there's a seller note or something like that. But that's all very deal and fact specific. One thing I wanted to revisit was we had talked about, Susan had mentioned audits, and if you're closing and there's an ongoing audit, that's a very fact-intensive question, whether or not you would still close, what the timing would look like, what the provisions would look like. But one thing you're going to want to consider are what are your rights around that audit and who is basically in control and in the driver's seat with respect to that situation and controlling communications with the government. And I think those facts can cut really both ways, and there's a lot to consider there. Susan, I don't know if you want to chat about that at all, or Jodie.
Kelsey, we've had that come up a few times, and I will tell you that's still just very, very fact specific. And I think it kind of depends on, is it a criminal investigation that's very serious and you might not even do the deal as a result of that until that's completely resolved. We've had just regular old civil audits, and especially during COVID, it's not unusual for an audit to go for a while. I've had examples where the audit started in 2020, but still hasn't wrapped up even in 2022. And so they think it's a good deal. They don't want to wait any longer, but we don't know what the results of that civil audit are going to be. In situations like that, that's where I want to look at those I-9s, kind of predict ahead of time what kind of penalties are we looking at, if any. And then you can, get everything together to kind of make a decision on whether you want to move forward. But, if you're on seller side, that might be a reason you can push the government to wrap up the audit. If you're on the buy side, you kind of want to be at least a little bit in the mix, so you're not getting a surprise out of that. But at the same time, you have to be a little bit cautious because there are higher penalties associated if there's a prior enforcement history. But let's say that we're doing an asset purchase where we want to let liability stay with the old company. In those situations, we sort of want to be careful to not insert ourselves in too much that you end up with, a penalty history that follows you, and you want to avoid that as much as you can. So those are some of the things I are typically thinking about, but it is very fact specific, as you mentioned.
This actually leads me to one more point that I wanted to make about being in control. One other thing that we've seen courts do is they usually strictly construe indemnification provisions against the person seeking indemnification. And so, again, a lot of times you'll see in agreements that provisions are not supposed to be construed one way or the other. But what we've seen is if you are the person that is prepared and suggested and relying on an indemnification provision, the courts are going to construe that against you. And so think about that in your drafting process as well.
That's a really good point. Something good to know. I always wonder what you see on the back end related to some of these different like control provisions and things in the indemnity and how they tend to play out among the parties, because there's definitely the way the contract's drafted, and then there's definitely how things happen in practice. But it's always interesting to have those takeaways. Is there any last thoughts? I know we're coming close on time for either of you that you'd like to tuck in here at the end.
Well, I think we've done a pretty good job of summarizing things that people should be thinking through as they're doing their deals. And I couldn't agree with you more. You know, when I get a contract that comes across my desk that's going to be litigated, you can always tell what people intended, but that may not always be the way things shake out, whether it be, you know, different factual scenarios or how courts interpret agreements and how provisions are drafted against or construed against one or the other party. But I think there's no substitute to having good counsel that you trust, looking at these things in advance so that hopefully you avoid the phone call to the litigator that ends up having to fight this for your clients one way or another.
Yeah, I think that makes total sense. I think that people often are not thinking about involving a litigator at this stage of the process. But as we have learned on our 3 episodes together, that is important because they have the horror stories, the tales of woe from past contracts, and they can lead you along a path that will help you navigate all of those different issues. And then for Susan, it's just like, I feel bad for the sellers walking into a situation where they're not really sure what their I-9 say. They haven't dusted off that paperwork in a long time. Maybe they've had the same workforce for a while and they're not totally in the know. And those are going to be pulled apart as part of the diligence process and definitely looked at and definitely brought up on a rep and warranty insurance call. It'd be nice for them to be prepared going into that. And on the flip side, for the buyer to have the knowledge of how to navigate those issues should any arise related to that in diligence.
Some good ideas to set some New Year's resolutions for all you deal lawyers out there.
Yeah, deal lawyers and prospective sellers and prospective buyers. If this hasn't been something that you've thought about in your past deals as a buyer, or maybe you're coming up on a disposition or intended disposition in the future, all things to keep in mind. And we certainly have the experts on hand here at McGuireWoods. So thank you, Jodie and Susan, for joining us today. It's always a treat to talk to you every year. It's one of my favorite episodes each year. So thanks for taking the time today. I really appreciate it.
Thanks for having us.
Thank you for joining us at the table for this episode of Deal Us In. If you have a recommendation for an inspiring interviewee, a question you'd like us to ask, or topic you would like to hear covered, or if you'd like to tell us about women-focused initiatives in the field, please email us at wpef@mcguirewoods.com. We look forward to hearing from you. This podcast was recorded and is being made available by McGuireWoods for informational purposes only. By accessing this podcast, you acknowledge that McGuireWoods makes no warranty, guarantee, or representation as to the accuracy or sufficiency of the information featured in the podcast. The views, information, or opinions expressed during this podcast series are solely those of the individuals involved and do not necessarily reflect those of McGuireWoods. This podcast should not be used as a substitute for competent legal advice from a licensed professional attorney in your state and should not be construed as an offer to make or consider any investment or course of action.